Ladies and gentlemen, dear colleagues, it is my pleasure to welcome you all to this new lecture of the cycle of talks given by Ukrainian academics. My name is Valérie Rousseau. I am a member of the Royal Academy of Belgium. I have this chance, and I have the pleasure to be with you and Dr. Gayane Nouritsanyan today. So the series of talks was made possible thanks to the hospitality of the Royal Academy of Belgium and the Collège Belgique in particular. So thank you very much for having us in this great settings. Even though we are online, it's still a prestigious kind of setting. For us at the Academy, the lectures are an extraordinary opportunity to grow up thanks to the expertise of Ukrainian colleagues and to build bridges between Belgium and Ukraine. And as I said 2 weeks ago when we launched the cycle of lectures, the message that we want to transmit is rather simple. And now I'm talking to Gayane particularly, but the point is, dear Ukrainian colleagues, you are not cut off from the rest of the world, and we want to reinforce our links now more than ever. So today we will have the privilege to listen to Dr. Gayane Nouritsanyan on the European Court of Human Rights and on the implications of Russia's exclusion from the Council of Europe. She will tell you more about it in a moment. Gayane, if I may, welcome on board. And let me introduce you very rapidly to the audience first. Gayane, you are a senior lecturer at the National University of Kiev in Ukraine, and you are also a postdoctoral research fellow at the Arctic University of Norway. It's a 2-year mandate, and you just started. After a master in law from the University of Kiev, you went to the University of Cambridge for an LLM, and then you started and finished your PhD at University College London. Your research focuses on human rights law, international criminal law, and settlement of international disputes. So, I mean, it couldn't be more appropriate, tragically. You have previously worked as a lawyer at the Council of Europe and the European Court of Human Rights. So it's great you have the practice and the theory side, which is so precious and rare. You were also a visiting legal professional at the International Criminal Court. So it's a terrific trajectory, I would say. Gayane, I thank you again for being with us today. We are all thrilled to listen to you. And you have the floor. Thank you.
Thank you very much, Valérie. I'm very grateful to you and your colleagues for organizing this series of lectures, for building cooperation with my colleagues. Ukrainian academic society and universities, like never before, need support. We will have a lot of work to do in the future with maintaining the academic community in Ukraine and educating students. And I think it's also very important to give voice to Ukrainian scholars, experts from Ukraine who are a bit closer to the context of these events, to express their opinion and perhaps take the international debate from there. I will then start my presentation, and I will share my PowerPoint presentation with participants. And today I will speak about the interstate proceedings between Ukraine and Russia before the European Court of Human Rights and the implications of Russia's exclusion from the Council of Europe. And I will basically cover 3 issues today. First, I will give an overview of interstate applications lodged by Ukraine against Russia. There is at the moment 10 applications that Ukraine has lodged with the ECHR. I will then talk about application of the European Convention on Human Rights to Russia's actions on the territory of Ukraine. And finally, I will address some implications of the Russia's exclusion from the Council of Europe for human rights protection in Ukraine more specifically. And as an introduction, I want to say that since the European Convention came into force for Ukraine on the big date of 11 September 1997, it has become a very important instrument of human rights protection in Ukraine. For the individuals who could not get redress of their rights at the domestic level, so they finally got an avenue to bring the state responsible at an international level, and more generally for the development of the legal system in Ukraine. There are a lot of decisions and judgments of the European Court of Human Rights where the court has commented on the structural problems and the gaps in the Ukrainian legislation related to ill treatment of persons in custody, related to pretrial detention, to the system of judiciary and disciplinary responsibility, to name just a few. And based on these judgments and the plan for the enforcement of these judgments developed together with the Committee of Ministers of the Council of Europe, Ukraine has been working, has implemented some changes to improve its legislation and continues to be working on bringing its legal system closer to or in compliance with the standards of the European Convention on Human Rights. And as we can see, as we will see in this lecture, it's not only individuals who have been addressing the European Court in order to protect their rights. Ukraine has also used this system of human rights protection in order to protect rights and freedoms of its residents and its citizens. And in fact, it started already in 2014 when Russia annexed Crimea. The first application was lodged specifically with relation to the persecution of Ukrainian and Crimean Tatar population in Crimea, starting from 2014, starting from the moment of occupation and annexation of Crimea by the Russian Federation. This application was declared partly admissible. Perhaps you know that before the European Court of Human Rights, in the interstate cases, you have the stage of admissibility and the stage of examination on merits separately. So the first court examined admissibility of the application and declared it admissible on the basis that Russia was exercising effective control on the territory of Crimea starting from 27th February 2014. Of course, it's not the function of the European Court of Human Rights to pronounce itself on the issues of territorial sovereignty, but nevertheless, the court touched on these issues in the admissibility decision and said that Russia is exercising control over Crimea not on the basis of territorial principle, not because the territory belongs to it, but because it exercises effective control on the territory of Crimea through the presence of its military and its representatives. I note an interesting fact that a similar application is pending before the International Court of Justice. So in respect of this problem, violation of the rights of the Ukrainian persons of Ukrainian origin and Crimean Tatars, Ukraine has also addressed the International Court of Justice. The issue, interesting issue that it appears here is how about the plurality of international proceedings? Would the European Court of Human Rights be prevented from examining this case given that it's pending before the ICJ? But in fact, the rules before the ECHR allow it to examine applications, interstate applications, even if similar application is pending before another judicial body. And I think it also tells us something about the perhaps the need or the absence of the rule of lispendence in the international law, and whether there can be a duplication of certain pronouncement on similar issues before different international tribunals. But on the other hand, it's important to note that here we have applications or claims brought under two different international instruments. Even if they relate to the same facts and the same parties, they concern distinct obligations of the respondent state under international law. Another application was brought by Ukraine against Russia in respect of the alleged human rights violations in Donbass region, and the application was also lodged in 2014. It was later joined with the application brought by the Netherlands with regard to downing of MH17. And in fact, the admissibility of this case was examined in January this year. Here, Ukraine claims that Russia is responsible for complying with the European Convention on Human Rights on the territory of Donbass in the eastern Ukraine because it exercises territorial jurisdiction on the territory of Donbass according to the practice of the court. When a state provides military, economic, and political support to a subordinate local administration, it basically enables such an entity to exist and therefore can be held responsible for complying with its obligations under the European Convention on Human Rights. There is also another very interesting case that was brought by Ukraine just last year against Russia, and it actually relates to the ongoing administrative practice of assassination by Russia of the opponents of its regime. And there is not much public information available what kind of cases Ukraine is actually raising here, but apparently this was connected to poisoning of Alexei Navalny, most recently in August 2020. So Ukraine is complaining that Russia is persecuting its opponents on its own Russia's territory. And also some instances of assassination of two Ukrainian colonels on the territory of Ukraine that Ukraine is also claiming that is basically done by Russian agents. Ukraine is able to bring this complaint against Russia with regard to the violations of human rights, alleged violation of human rights that take place on the territory of Russia and on the territory of other states because of this objective character of the convention and erga omnes nature of the obligation. So the state, as we know under the European Convention, does not necessarily need to be a victim, so to say, of the violation of the convention in order to raise the issues of human rights violations before the European Court of Human Rights. This case, this application brought by Ukraine is actually very similar to an individual application decided by the court in 2021, which is called Carter versus Russia. And Carter versus Russia is a case that relates to assassination, more specifically poisoning with polonium of a Russian dissident who fled Russia and settled down in England, Alexander Litvinenko, who was then poisoned by two persons acting as Russia's agent, according to the judgment of the court. And in this judgment, the court said that Russia was exercising its territorial jurisdiction on the territory of Great Britain because it was because the agents of Russian Federation were exercising control over the life of the victim. So basically, the state's obligation to comply with the European Convention on Human Rights are triggered in cases of extrajudicial targeted killings by the state agents on the territory of another state. And this case, as I will discuss later, is also important and can have a potential effect on examination of complaints related to the current ongoing conflict between Ukraine and Russia. Just briefly, two other cases that are pending before Ukraine and Russia is the incident in 2018 where Russia detained 24 sailors of the Ukrainian Navy captured in the waters of Sea Azov. As the Ukrainian governmental agent before ECHR said, this was a technical, as you called it, application, and basically was submitted by Ukraine because Ukraine did not know what happened to the sailors, and the submission of an application and request for interim measure before the European Court of Human Rights allowed it to request more information from Russia. So through this means of starting an application before the ECHR and requesting indication of interim measure, Ukraine could find out what was happening and what was the condition and whereabouts of these sailors detained by Russian Federation. Last year, there was also an application by Russia against Ukraine related to alleged persecution of Russian-speaking population in Ukraine and claiming that Ukraine itself bears responsibility for the downing of MH17. Finally, on 28 February 2022, so this year, 4 days after the start of a full-fledged aggression of Russia against Ukraine, Ukraine addressed immediately the European Court of Human Rights with the request to indicate interim measures to the Russian Federation. The court basically agreed with Ukraine and said that there was a real and continuing risk of serious violations of the conventional rights of the civilian population, and requested that Russia refrain from military attacks against civilian population and civilian objects, and later also indicated that Russia should respect the humanitarian corridors and respect the evacuation routes for the civilians, including in the safer regions of Ukraine. Because there has been some reports that Russia have been organizing evacuation routes, but mainly to the Russian territories. So the court specifically mentioned that the Russia should ensure or allow civilians to seek refuge in safer regions of Ukraine. Two aspects that I want to discuss with regard to this case. First of all, the effectiveness of these kind of interim measures in intrastate cases. And second of all, it's actually the application of the convention to the actions of Russia on the territory of Ukraine. In view of the court's recent jurisprudence that actually suggests that the convention should not apply to the phase of active hostilities. Interim measures, as you know, are adopted when there is an imminent risk of irreparable harm to rights guaranteed by the convention. They're usually adopted individual cases, meaning, for example, if the person is about to be deported, the state can stop the deportation. And we just saw the European Court of Human Rights stopping the flight to Rwanda in the UK, and UK reacting quite dramatically to it, to this, according to them, encroachment on their own legal system. The court also adopts interim measures when the person is in detention and is not provided with necessary medical assistance, so the court can order the state to provide the person with necessary help. And in individual cases, it's actually easy to measure the compliance with these interim measures. In the cases like Ukraine versus Russia, in the armed conflict, it's much more difficult to measure when the state is actually complying with the interim measures. And the character, the way that they are formulated, is quite abstract. So it's not really clear, and some scholars believe that actually the interim measures, ordering interim measures in those situations, they are not effective, and they only undermine sort of the standing of the court, whose interim measures orders are not complied with by the states. There has also been a question whether the order of interim measures is of mandatory nature. And the court has resolved this issue with regard to interim measures in individual cases, but the court has not said anything about the interim measures in interstate cases. However, we can see that the reasoning behind the mandatory or binding nature of interim measures indicates that it is indeed mandatory in interstate cases as well. So they are adopted in order to protect the person from irreparable harm, and actually to allow the court to deliver, if necessary at a later stage, a decision that would effectively protect the person's rights. Basically to stop a situation where an irreparable harm to the rights by the convention can be caused. I think that regardless of the discussion of or any sort of reservation with regard to the effectiveness of interim measures in interstate cases, they are very important, because in the situation of the armed conflict between two states, they signal to the states that there is a body that is actually supervising their actions. So there is a system of human rights protection that is involved and can hold them accountable for what they are doing. So I think in this situation, even for this function of signaling the presence of a supervision, the interstate interim measures can be important. Much more complex question is the extraterritorial application of the European Convention to active phase of military hostilities. So last year, in January 2021, the court delivered its judgment in the case of Georgia versus Russia, which concerned a conflict that happened, military conflict that happened between Georgia and Russia in 2008. During 4 days, there was this active hostilities, artillery shelling, bombing between the states, etc., between the military forces of the states. And this active phase of hostilities was then succeeded by a period of occupation. So the court believed that the convention does not apply to this period of hostilities. So the convention did not bind Russia when it was engaged in the phase of active hostilities on the territory of Georgia. Some of the reasons, or the reasons that the court advanced, was that actually the whole situation, or I should start from a different point. So in order to find that the state is bound by the convention, the court usually has to establish that the state exercises effective control over territory on the territory of another state, or effective control over a person. And in this case, the court said that the phase of active hostilities actually is the opposite of exercising any type of control, because when the states are engaged in active combat, they basically are fighting for establishing effective control over a territory or over the persons. So the existence of active hostilities in of itself indicates the absence of effective control, and therefore the states, the foreign states' jurisdiction on the territory of Georgia in this case was not engaged. The court also mentioned that this situation was regulated by other norms of international law, such as international humanitarian law, and the court also referred to the multitude of evidence and victims and the difficulty of establishing of what actually happened in these circumstances of active hostilities. I think that a similar approach, at least not fully, cannot be applied to the situation in Ukraine. The situation in Ukraine is different from the 4-day armed conflict that took place, or at least the 4-day active phase of the armed conflict that took place on the territory of Georgia. In Ukraine, the court has to adopt a different approach, even if it wants to continue with this line of non-application of the convention during the active phase of hostilities. The court has to take a case-by-case approach, deciding in each particular case whether there was a control by Russia on the territory of Ukraine or on a specific person. Why? Because indeed the conflict has now been pending at least since February for 116 days, so 17 days. And the situation on the territory of Ukraine is very diverse. We have parts of the country that have been occupied by Russian forces and where they have been exercising control from the very beginning. For example, in Kherson region in the south. We also had certain periods when territory of certain towns or villages, especially around Kyiv, Bucha, for example, was also under the occupation of Russian military. So in these situations, one cannot deny that actually there was effective control on the ground. There was an effective control over the territory of Ukraine in those regions by Russian forces. And that should trigger the application of the convention to Russia and trigger its obligation to comply with the convention. There have been also instances of control and authority over Ukrainians or persons residing in Ukraine by Russian military. And I'm talking about cases again of torture, kidnapping, forced disappearance, willful killings, such as we saw in Bucha, of people with hands tied behind their backs. We have also reports about sexual violence and rape, and these are all instances of exercising of control and authority over a person that also, according to the practice of the court, including the latest judgment of Carter versus Russia, triggers the application of the ECHR to the actions of the state. And finally, I think if compared to the situation with Georgia and Russia, the conflict in Ukraine is much better documented, and there is much more information about what has happened and when. And that can also serve, can be useful for the court in establishing the circumstances of each particular case. So I believe that the situation in Ukraine, at least since February 2022, should be treated differently by the court and should be examined on case-by-case basis, rather than applying the Georgia versus Russia conclusion on active hostilities and non-application of the convention to active hostilities to the whole period of war in Ukraine and to the whole territory of Ukraine. This conclusion is, of course, valid only if we are talking about the period while Russia remained or still remains party to the European Convention of Human Rights. You know that in March, Russia was excluded from the Council of Europe, and that has, of course, implications for it being party to the European Convention of Human Rights. In March, the European Court in plenary session declared that Russia ceases to be a party to the convention on the 16th September 2022 on the basis of Article 58.3 of the convention. There are a lot of debates about the interpretation of this provision and whether Russia does indeed remain bound by the convention for 6 months, or if it stops to be bound by the convention from the moment when it was excluded as a member from the Council of Europe. But I will not go there. It's enough to say that the court interpreted the convention as such that applies to Russia until the 16th September 2022. It's also important to say that just recently, I think around 10 days ago, Russia voted for the law that said that it would not execute any decisions or judgments of the ECHR, which were delivered after 15th March 2022. And 15th March is when actually Russia gave notice of its withdrawal from the Council of Europe. So even if the court believes, or the Council of Europe believes, that the Russia is bound by the convention for another 6 months, there are significant doubts about Russia's involvement in execution of the judgments delivered after mid-March. What are the implications of Russia's exclusion? Well, first of all, lack of the protection of the European Convention of Human Rights, both for people who reside in Russia, for residents and citizens of Russia in relation to their own government, but also for big part of the territories of Ukraine, which are occupied by Russia. We are talking about Crimea, we are talking about Donbass, which have been under Russia's occupation and control until the full-fledged invasion, but we're also talking about the territories or newly occupied territories, such as, for example, southern parts of Ukraine that have been occupied since February this year. So we are faced in a situation where the person lives on the territory of the state that is party to the European Convention on Human Rights. So this territory is part of the legal space of the Council of Europe and European Convention on Human Rights, but because they find themselves under the occupation of the state that ceases to be party to the convention, they cannot actually rely on the protection of the European Convention on Human Rights. I mentioned already the potential non-participation of Russian Federation in cases brought against it before it that are still pending before the court, and I think 1/4 of the cases, perhaps around 18,000, if I'm not mistaken, applications are pending before the court against Russia. So this will present a considerable challenge for the court as well, examination of these cases. And of course, among these cases are also individual applications brought in relation to Russia's actions on the territory of Ukraine. Some have raised issues that about the legitimacy of the future judgments of the European Court of Human Rights, which will likely be delivered without Russia's participation. When one must say that any debate about lack of legitimacy is actually the result of Russia's choice to be absent and not to participate in the proceedings before the European Court of Human Rights. One question that arises here, how about the judge that is elected in respect of Russia? So usually in the system of the court, any cases examined before the chamber or the grand chamber against a state should involve the judge elected with respect to this state. But at the same time, the convention provides that only judges of the signatory states can sit on the court. So it seems like the judge in respect of Russia will sit on the court only until the 16th of September 2022. And then the question arises, how will be the judgments in respect of Russia delivered after this date? One must say that judges sit on the court, they don't represent a state on the court, they don't represent their country in the sense that they are not acting on behalf of their country, they represent more the legal system and sit there. Their participation in cases against their own countries is valuable because of their knowledge of the context, because of their understanding of their society and the legal system. So in that respect, of course, the participation of the judge is very important. But one must also say that the drafting of the decisions, judgments before the European Court of Human Rights is often done by the lawyers from the legal system, from the country against which the judgment is delivered. So in that sense, the knowledge of the context of the legislation, of the culture, of the practice can be actually found on the level of judicial clerks who work in the registry of the court. Another issue is, of course, evidence. Court examines the cases on the basis of the application and delivers the judgment when it has had the response to the claims of the applicant from the government. And how will the court deal with a situation where the government is not cooperating and is not providing its own view of the situation to counter the claims that are lodged by the applicant? I think here, at least when we talk about the situation in Ukraine, it's important to say that the cases brought against Russia with regard to actions on the territory of Ukraine, the court can have access to the evidence on the territory of Ukraine through the participation, at least of lots of third parties. So there are a lot of international actors, non-governmental organizations who work on the territory of Ukraine. There are also a lot of different mechanisms that are involved in what is going on in Ukraine. The UN Commission of Inquiry, for example, the International Court, Criminal Court is working in Ukraine as well, or the prosecutor's office. This may be also the time for the court to return perhaps to its fact-finding mandate that it has been exercising at the beginning of its existence. So the absence of the respondent may affect the adversarial nature of the process before the European Court of Human Rights, but that does not necessarily is an impediment for the court getting access to the necessary evidence, at least when it comes to the cases in relation to the alleged human rights violations on the territory of Ukraine. Russia's non-participation will undermine, without any doubt, the enforcement of the judgment of the European Court of Human Rights. Some experts say that they will become only symbolic, but in fact, for the victims of human rights violations and the war in Ukraine, I think that can have a very significant and very important meaning as well. So it's not perhaps only about receiving a compensation for the violated rights, but it's also about obtaining recognition and some kind of confirmation, validation of the applicant's stance and the recognition of that the person has suffered from the actions of one state or another, in this respect, from the actions of state agents of the Russian Federation on the territory of Ukraine. Finally, it may also be the time to engage other instruments of human rights protection that are available there. UN system has some instruments, including of examination of individual complaints through the International Covenant on Civil and Political Rights, the Convention Against Torture, the Convention for Elimination of All Forms of Racial Discrimination. Russia has recognized the competence of committees to examine the individual complaints under these international instruments. Of course, their system of implementation is much weaker than the European Court of Human Rights, but nonetheless, it's also a mechanism to bring state to international responsibility, at least through a decision, a view, a jurisprudence that can decide on the compliance of the state with its human rights obligations. We also often talk about international humanitarian law as the regime that exists in parallel, but it is based on the idea of respect for humanity and also contains some of the guarantees that are found in human rights law and human rights instruments. For example, Article 75 of the additional protocol that contains minimal guarantees also has basic human rights guarantees related to the protection of persons' integrity, prohibition of torture, right to fair trial, for example. So perhaps making an emphasis and strengthening the compliance with international humanitarian law norms by the states. And finally, we can see that in the situation of Ukraine, that the emphasis has shifted a lot to the accountability for war crimes and the crimes against humanity, which are basically, at least crimes against humanity, an example of the violation of mass scale human rights violation. And here the emphasis has shifted to the individual responsibility, because of the state can withdraw from the treaties and the conventions, but actually the issue of individual criminal responsibility remains, and the international law continues to apply to the individuals who are responsible for the crimes committed on the territory of Ukraine. International Criminal Court has also and is now recognizing more and more in its jurisprudence, in particular in Taganda case, that reparations regime, even though the decision on reparations comes at the very end of the proceedings before the ICC, is actually one of the central elements of the system. And perhaps this is also the way for victims of human rights violations and international crimes in Ukraine to get redress for the violations of their rights.